Hi, I'm attorney Deborah Stevenson. I'm founder of National Home Education Legal Defense, and I'm here today to try to answer some more questions on the rights of parents. Today's question is all about equivalent instruction. Since we don't have anyone shouting it out from the crowd, I will just start talking about equivalent instruction. Now, there are a lot of people that are confused about that term. Do parents who instruct their own child at home have to meet any standard of equivalent instruction? The answer to that is no, okay? Because the duties of parents appears in Connecticut General Statute 10-184. That statute has a couple of different parts that are important to distinguish. The first sentence of that statute says, in essence, that all parents shall bring up their child in some lawful employment and instruct them in certain subjects, okay? Period. That's the first sentence. Instruct or cause a child to be instructed in those subjects that are listed in the statute. That obligation has been in Connecticut law since the Code of 1650 in one form or another. The second sentence of 10-184 talks about parents who have children between certain ages, and it's what's known as the compulsory attendance portion of the statute. In other words, this came into being when parents were not undertaking their obligations so much and sending their children to the factories in the 1880s so that they were not getting instruction in the subjects listed. So the compulsory attendance portion of the statute was added that says parents who have children between certain ages must send them to a public school unless those children are receiving equivalent instruction, unless the parents can show the children are receiving equivalent instruction. And that's where the term equivalent instruction comes from. Now, if you think about it logically, there are two distinct obligations under Connecticut General Statute 10-184. The first and foremost, children shall be educated by whom? By their parents. That's the first sentence. All parents shall bring up their child in some employment and instruct them in these subjects, okay? That's a given, period. There's no phrase attached to that listing the subjects and saying the children must receive instruction in those subjects that is equivalent to any public school. That does not appear. The first sentence of the statute says parents shall bring up their child in some lawful employment and instruct them in those subjects, period. You are free to do that in whatever way you want, in whatever manner you want, whatever time frame you want, and with whatever materials you want. There is no qualification about that. If you are not doing that, if you're not undertaking the obligation to instruct your children or cause them to be instructed in those subjects, then if you have children between those certain ages, you must send those children to public school, unless at that point you are able to show they're being given equivalent instruction elsewhere. Now, if you think about it logically, if you are not instructing your child or causing them to be instructed, and you're not sending the child to a public school, where else could you show equivalent instruction? The answer to that is in a private school, of course. And that's how we have interpreted that statute. There has been no legal interpretation in any other fashion about that phrase, equivalent instruction. And in fact, if you think about it logically, if anyone tried to define equivalent instruction, how would you define that? The public schools cannot even define equivalent instruction from one public school to another. So in essence, what the statute is saying is children must be educated in some manner, first and foremost by parents. Secondly, if you're not going to do that, by the public school. And thirdly, if you're not going to do either of those two things, then you can show that they're being given some sort of equivalent instruction elsewhere, namely in the private schools. I hope that clears things up. Thank you.